Dear ladies and gentlemen, I would like to first of all thank the Procedural Law Unit of the University of Nicosia and the International Association for Judicial Independence and World Peace for organizing today's symposium and for dedicating it to the very important topic of judicial independence. Key role of independent courts in democratic societies cannot be overstated. Without independent courts, there can be no rule of law, no freedom or equality, and no guarantee that fundamental rights are respected. And without respect for the rule of law, there can be no EU legal order, no functioning European Union. And it can therefore not come as a surprise that the European Commission attaches great importance to promoting and upholding the rule of law and judicial independence in the European Union. Over the past years, the Commission has expanded and consolidated the tools and instruments at its disposal to promote and uphold the rule of law and judicial independence in EU member states. At the heart sits the Commission's annual Rule of Law report. Every year, the report takes stock of the rule of law situation in all member states and the EU as a whole, assessing in a structured manner significant national developments, both positive and negative. And judicial independence is one of the key topics monitored under the report. The report assesses whether member states of the EU respect the requirements set by EU law and by the case law of the Court of Justice, and it also refers to European standards to be taken into account in the design of national justice systems. And since 2022, the report also includes recommendations to member states, and in some cases, these recommendations specifically aim at strengthening judicial independence. During the last years, the Court of Justice of the European Union has developed an impressive body of case law, further clarifying the requirements of EU law on judicial independence, and this body of case law continues to grow. The case law is being developed following a range of infringement proceedings, which the Commission has brought before the Court of Justice against member states where judicial independence came under threat, and also following multiple requests for a preliminary ruling from national courts addressed to the Court of Justice. And as confirmed in this case law, judicial independence presumes first external independence, where the court can exercise its functions autonomously without being subject to any hierarchical constraint or without being subordinated to any other body, but it also requires internal independence, where individual judges are protected from undue internal pressure from within the judiciary, and also impartiality, where an equal distance is to be maintained from the parties to the proceedings and their respective interests. But it's not only EU institutions, national authorities, or the judiciary itself that are responsible for promoting and upholding the rule of law. This is a collective responsibility of all of us, including of bar associations, of civil society, and obviously also of academia. Standards on judicial independence, such as those of the ELI Mount Scopus standards, that will be the topic of discussion today, provide an important contribution in that respect. These standards show the multiple dimensions that judicial independence has. For instance, the first section of the standards on the foundations explain in a very clear and concise way what judicial independence means, why it is important, and what it requires. And the standards address many other pertinent topics: separation of powers, security of tenure, irremovability, the composition and the balance of judicial self-governance bodies, and the fundamental role of selection, appointments, professional evaluation and promotion. But it also goes into the challenges of technology and its development. Of course, the standards may not have a tailor-made solution to all the specific challenges encountered in a particular justice system, but they clearly help to further clarify the concept of judicial independence, and thereby they contribute to strengthening a rule of law culture. And this is very important at a time where the rule of law is under threat in some countries, and very important for ensuring the respect of fundamental rights and democracy in Europe and across the globe. So I very much welcome today's symposium as an opportunity to deepen the reflection on how to protect and strengthen judicial independence, and I wish you a fruitful discussion. Thank you.